Hello, everyone. This is Seth Bloom. I'm the Senior Director of Attorney Services at Levelset here in New Orleans. We've been doing webinars for the past couple months, and I know these have become even more popular and important during everything we're going through with COVID. Today, two of our experts and two of the members of the Attorney Network and Expert Center have decided to participate on this great webinar today. So I'm gonna introduce Andrea Goldman. She's an attorney in the greater Boston area. She also works in the capacity as a general counsel, but I'll let her go in more depth. We also have Tom Majeure, and he's in the insurance industry and has had a lot of experience with that. So I think the combination of both of them are gonna give you a great insight into what we're gonna talk about today. So Andrea, I don't know if Andrea or Tom's gonna go first, but whoever wants to go first, we look forward to hearing from you. And please, everyone out there, ask questions. We can wait till the end. If some questions come up in the middle, please ask them. So we look forward to a good webinar. Thanks.
So hi folks, I'm Andrea Goldman. I am General Counsel of the Builders and Remodelers Association of Greater Boston, which is part of the Home Builders. I'm also a member of the National Association of the Remodeling Industry, and I've been a construction lawyer for 30 years. Tom, who's going to be speaking a little later, is a construction expert in the insurance industry. And I just found out he beats me by 7 years. And we're here to help you. Since this pandemic has started, I've had clients calling me on a regular basis with questions as they arise about what they can do and what they can't do with what's happening out there in construction. This is not going to be a state-specific presentation, but we'll try to answer your questions as best as we can. Of course, Tom and I are very familiar with Massachusetts and more of what's going on in New England. But I called this presentation Coronavirus in Construction Getting Back to Work because people are trying to get back to work and the states are opening up. So today we've got an introductory slide. The first question that came up with and is coming up with my clients is, can I work? Can I keep working? Can I go back to work? And also, how can I work safely? So we'll talk about the guidelines that a lot of states have been issuing about what is considered essential and what is not. And that varies enormously from state to state. Another issue that we're running into is clients who don't want to work. They either want to suspend contracts or stop contracts, and they want to be able to do that without suffering financially and being penalized. And then and there are two ways that hopefully you're going to be protecting yourselves when you do return to work. And one is through your contracts. You're going to need to be revising your contracts and including pandemic-related clauses. I've been working on those for clients. And then the insurance considerations, which I've been learning this week, are huge in terms of what your insurance is going to cover and not going to cover. Oops. Okay. I think I had
Andrea.
ahead of myself. Yeah.
Again, real quick, and as you know, I'm an attorney too, and basically, and I know you're about to talk about this, but I found it really interesting. Yesterday, I saw the first kind of class action TV commercial about suing insurance companies for business interruption insurance, and that seemed to be something that wasn't available to an epidemic situation. So I'm sure that everyone out there is interested in knowing a little bit more about that as well.
Well, we're definitely including that in this presentation, but that's a Tom question. So Tom, do you want to say something about business interruption insurance?
Tom, why can't we sue you?
You can't see me?
Sue.
Sue. Why can't everyone sue you?
Well, they can. This is America. Anybody can sue anybody. Most policies for business interruption to be for the policy to pay requires physical damage to the location that, that we would cover the interruption for. So if you were a restaurant and you had a fire in your kitchen, that's a covered peril. You're shut down for a couple of months, we would cover that. There has to be, most policies require physical damage to the location for a business interruption policy to become effective. So that's really where the issue comes into, and there's a lot of, as you said, there are a number of different lawsuits right now, and there's also a number of different legislatures that are looking at it as well to see what they can do about that. But the policies as they're written really did not contemplate something like this.
So an important question, and hopefully something we're going to take care of in those contract clauses that you're going to be including in your contracts from now on. So the first question, and I think most of you know this already, is most states are only allowing workers to continue with working if their business is considered essential. And you need to be able to find out whether the construction work that you're doing is considered essential. So I can tell you Massachusetts is a really interesting state to be in, because we've had fights between the governor and the mayor of Boston about what's essential and what isn't. And we've also had fights between the cities and the towns about what's essential. So the first thing to do is to go and check your state regulations, and those will be on your state websites. I know that Massachusetts has COVID updates and FAQs, frequently asked questions, on their website about what you can and cannot do. And I have had the good luck of speaking with another attorney in Massachusetts who's a lobbyist, and asked him about the interpretation of some of these definitions of essential services. And he says, just to make it all easy on us, that Massachusetts has been deliberately vague. And the reason that they've been vague is that they want to allow some wiggle room for what people can and cannot do. And it also depends on who's lobbying. I know here, the landscapers lobbied heavily, and landscaping is considered an essential service. The home builders lobbied heavily, and home construction is considered an essential service. Strangely enough, though, in the last order from the governor, they said you can only do construction housing for housing that is going to address the housing shortage in Massachusetts. So what does that mean? I got in touch with my buddy and I said, okay, does that now limit us to only projects that are going from, let's say, a single family home to multifamily, or that are constructing apartment buildings, condominiums? What does this mean? And is this intended to further limit construction? And he said, no, 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 they didn't intend to further limit construction. But the city I live in interpreted it very strictly, told all the builders they had to stop working, and said, unless you are working on a project where you are literally increasing the amount of housing in Massachusetts, we're shutting you down. So people are up in arms. Now, in some states, I have done a little bit of a research around the country so that I could hopefully be a little more helpful to you folks. You can apply for a waiver for your specific project in order to be able to keep working. And here it's called an essential service designation request, but I'm just suggesting that that is something that you look for. Finally, you've got to use your common sense. If you are working on an addition and the owners have to move out of the house and they're living in a hotel, they are exposing themselves to the public and they're putting themselves in a potentially dangerous I don't know if I'd use the word dangerous, but they're exposing themselves to the potential for contracting the virus, getting them back in their homes is really important. So in that case, you may be able to justify continuing work. If you're about to start a bathroom reno and you haven't even gotten started, forget it, you're not doing that now. On the other hand, if you're working on a new construction project, and you can maintain social distancing and no one's living at in the premises, then yes, you can move forward. So I think you've got to look very carefully at your own specific projects and figure out first whether they are essential. Now, obviously, if you do public construction, if you work on utilities, anything along those lines, of course, those kinds of projects are going to be considered essential, but then we have to get into the safety guidelines and the kind of precautions you have to be taking. So, speaking of safety guidelines, OSHA has this really, really nice chart on their website for what is required of people if they're going to be going out and working. Taking a look at it, I can tell you that it is not as strict as some of the safety guidelines that I have seen. For example, for public construction in Massachusetts, they require a COVID designated officer on site during the construction. There are guidelines about workers taking their temperature before they come to work. They also have to get to work by being in a vehicle with, I think it's no more than 2 people. I don't know if Tom remembers. So those guidelines are going to be even more strict. So start with OSHA, take a look at OSHA, and then look at your state and local guidelines. And again, we have a conflict between what the state in general is requiring and local cities and towns. Massachusetts today, the governor just announced that everybody has to wear a mask when they go outside. Brand new, just happened. I think you'll find that in reality, workers are not necessarily wearing masks, but they're being told that they should. So you've got to look at your state guidelines, but you also have to look at your city guidelines because some cities are stricter than others. Any questions out there yet? Okay. So the first
Like a quiet room right now.
Okay, well, I hope that means people are listening and not sleeping. The first question that I got when all of this started was from a client who called up and said, we want to suspend all our jobs, you know, until we know more about how this illness is working. We want to suspend everything for 2 weeks. That's pretty much where we started. And she said, can I do that? And in typical lawyer parlance, I said, it depends. So the reason that it depended is because in law, we always go back to the contract. And hopefully most of you have contracts that have what's called a force majeure clause. So what is a force majeure clause? A force majeure clause is a clause that pertains to acts of God or natural disasters. So what that's saying is, in the event of, and most of you will have something along these lines, tornadoes, various acts of God, worker strikes, that sort of thing. Maybe if you're in the South, it might include flooding. We have the right to suspend or to postpone work. So the question becomes, is a pandemic, God, is it considered a natural disaster? And that is something that is going to be litigated big time, I think, throughout the country. So let's go back to what is the purpose of all of this? The purpose of all of this is who is going to bear the financial risk of this pandemic? Is it going to fall on you because you want to stop work because you need to protect your workers? Or is it going to fall on the owner who wants you to come in and do the work? And I've seen this happen in many different guises. There are some owners who are saying, I don't care what's going on, I want you at the job next week. And then you've got owners who are saying to suppliers, why is your stuff late? I have a client who manufactures windows and doors, and they're saying, we need those windows and doors. And he's saying, well, I have a supply chain problem. I can't get the parts from, I believe, some manufacturer because that's being held up. So the only way to truly protect yourself, because as Tom said in the beginning, you can't stop people from suing you, is to have something you can point to in your contract that says, in the event of a pandemic, natural disaster, government orders, and I'll tell you about the government order piece because I just put that in this week, or other force majeure events, in order to protect the health and safety of workers and customers, we have the right to suspend or cancel projects. Now, I've been doing my homework, and the question becomes, is the pandemic keeping you from working, or is a government order preventing you from working? And again, this is all about who is going to bear the financial risk. There's case law out there that says that if you don't put in, the government told me not to work, you might not be able to defend your position of stopping working. I know that sounds crazy, but again, you want to spell it out. And in terms of stopping or not stopping work, basically, you can point to the clause. Again, that's not going to keep someone from suing you, but at least it'll be something that you can use in your defense. Now, yes, Seth.
Andrea, sorry, I know I'm going to break you up in thought for a second, but someone had a good question from earlier about, enforcement of these things. What happens if you don't wear a mask and you're out on a construction site working? I mean, are the police coming by? Is that different for each municipality? I mean, is it just kind of like on the books? Any thoughts on that?
That's a great question. I think it will vary enormously. I've heard of cities and towns here fining people. I've heard of situations where, nothing's happening. I mean, my best example of this is, I think all of you remember the EPA RRP rule that came about if you're in the home renovation or industry, where you had to use certain lead containment procedures if you were working on homes built before 1978. And when it first came out, it was an Environmental Protection Agency rule, and it came out and everybody was up in arms that there were going to be people enforcing this, and the fines were enormous. They were $37,500 per day per infraction. And all the lawyers tried to learn about it and whatnot. And fast forward to today, I've heard very little about it being enforced. So, these laws are enacted, but this whole presentation is really about how risk averse are you? If you're not concerned about risk, do whatever you want. If you are concerned about risk, what can you do to protect yourself as much as humanly possible? And that's really what it's about. So I would say, read your local news, find out whether people are actually enforcing all of this. I do want to say one other thing. If you don't change your contracts, if you decide to stop work or suspend work or break your contract with somebody, there's also a general rule in law that comes into play in these lawsuits, which is public policy considerations. So even if you don't have something in your contract that allows you to stop work, and you get up in front of a judge and you say, my workers are all in their 60s, they're all at risk, I couldn't let my workers go to work, catch-all. That's what might save you in this situation and make it so that you still have a right to stop work. So it's definitely an argument you can make. So what can we put in our contracts? People are hopefully going back to work. Various states are opening up. What can you put in contracts to protect you so that when you go back to work, you're not going to be facing litigation and disputes with people about whether you're working, how you're working, so on and so forth. So the first one I talked about a bit already is force majeure. Having something in there that says, not only do I have a right to stop work because of this pandemic, but I have a right to suspend work, because we've all been hearing about this second wave. We all know that we might go back to work and then have to retreat back into our homes and quarantine ourselves again. So you need to have that a right in your contract. The other thing that you want to do is you want to have a clause in your contract that allows for delay, because this situation is delaying people. You're going to have suppliers who are delayed in getting you materials. You may have delays if you or your workers get sick. You may have delays just because the government is telling you that you need to be more restrictive about the way you're working. If you have to socially distance at a site, maybe it's going to make your situation less efficient. You're not going to have good concurrency in your construction methods, and you're going to have delays. Another place where you're going to think about clauses in your contracts are indemnification clauses. I don't want to ruin Tom's thunder here, but a client who said, I was going to go do renovation work at a house, and the homeowner checked with their home insurance, and the home insurance said that the policy would not defend the owner if the contractor sued the owner for transmitting the virus to them. So what we as lawyers do is we draft what's called indemnification hold harmless clauses. And what we say is, if you transmit the virus to me, owner to contractor, then I am going to hold you harmless. I am going to protect. I'm going to protect you from any lawsuits. I'm going to defend, and I'm going to pay you back if you are held liable. If one of my workers sues you, I won't sue you. I won't have any suppliers dropping off materials suing you. It also needs to go the other way. The owner is not going to want to be sued for giving you or your workers the virus. Then you get into contracts with your subcontractors. If an electrician comes on site, I mean, I saw it honestly going on outside my front door. They're installing a new gas main. 3 guys working, digging a trench, digging up the driveway. One of them has a mask. The mask is down around here. The other 2 don't have masks at all. They're 3 inches from each other, and they've been working out front every day. So somebody comes in and goes to drop off some materials, or is a plumber and is going to be connecting the pipes, and he gets COVID from one of the workers. You know, you want to have contracts with your subcontractors that makes it so that you are not liable for that. It's hard to prove. Go ahead, Seth.
Andrew, I think we have some good questions here from some people out in the audience. And those other ones, 1 or 2 of those other ones were participant questions, not my own. But this is a bit of a long one, but it's right on point. Great point on the government order and the force majeure clause. It seems belts added with suspenders. One governing agency shutting down, and 2 there's a pandemic. I'm interested in brainstorming or thoughts on suspending under force majeure when the interpretation is strange that the insurance companies are saying that is not a defined event or contemplated event. I think they lose, and I think that an owner would lose here. Since 2000, as a young lawyer, I added terroristic threats, disease, etc. for force majeure. I think the broad terms cover. Thoughts?
Well, good for you for adding that to your contracts. I mean, one of the articles, force majeure is supposed to be for events that are not foreseeable, okay? And there are going to be people who argue that this was foreseeable. There have been people predicting pandemics now for quite some time. This isn't the first coronavirus that we have had in recent history. We've had SARS, we've had MERS, we've had Ebola. They just have not been worldwide. And, what I say to clients frequently is you can win the war, okay? You can have a lawsuit, you can get sued, you can defend yourself, and you can win. But in the meantime, because you have the battles over what does force majeure mean, the legal fees are so excessive, and you've spent all this money just to defend yourself, and that's money that generally you can't get back. I don't want to get too technical here, but a lot of people put what's called prevailing party clauses into contracts. And that basically means that the person who wins in a lawsuit, the prevailing party, may get to collect their attorney's fees. And the attorney's fees rules vary from state to state. I know I believe my associate is on from Florida. And in Florida, when you're in mechanics lien litigation, you get your attorney's fees back. I can tell you in Massachusetts, you don't get attorney's fees unless it's in your contract. So the point being, we're trying to keep you from getting into those lawsuits because lawsuits are super unpleasant, expensive, and they distract you from your business. Now, I think part of this included insurance. Did you hear something there in insurance, Tom, about whether it's foreseeable?
I think there was a question there about, and I may have said that it wasn't contemplated. And I probably misspoke there. The real thing is for a business interruption claim to be collectible, there has to be physical damage to the location. In this case, the argument is there isn't any physical damage. I didn't have a fire in my kitchen. I didn't have a tree fall on my roof. I didn't have, a car drive through my front window. What's the physical damage that shut this, that shut the restaurant down? And I don't think there is a physical damage. The fact that there's a virus in the community and the government said you got to shut down, that's not physical damage. And I think that's the art, that's where the insurance industry sits on this thing.
Well, I'll tell you what, Andrew, you're starting to give me anxiety because for 6 to 7 years, I did nothing but post-Katrina litigation of the difference between wind-driven rain and rising floodwater, which sounds like it'll be, a similar kind of argument with the business interruption. And I know Tom's laughing because I'm sure he remembers some of those claims. But Paul has a really good question. I'm interested in knowing what the answer is. And he says, well, what happens if someone on the site is diagnosed with COVID-19? Is the site required to shut down for a safety stand down?
Well, that raises a whole lot of interesting questions. And, we don't have to be, stuck with our slides. We can answer the questions out of order. So first of all, you got to look at the safety regulations and you've got to look at your government regulations. Every day, I don't know if the rest of you are glued to CNN, but we're talking about contact tracing and we're talking about self-isolating if you've been exposed. I mean, someone gets diagnosed at the site. Obviously, they can't come to work. So let's start with that. That person can't come to work. Then they talk about the degree of exposure. Before we used to say, if you're exposed to somebody, you now need to self-isolate for 2 weeks. But what is exposure? Is exposure someone handing you a bag at the grocery store? I'm using this example because Dr. Fauci used it last night. Or is it the person standing next to them who's been bagging all day? I think the answer is it would depend. And our Department of Public Health here is very useful. We have a hotline you can call that's very useful. But, you know, if the guy who's been sitting in the Bobcat all day is the one who now tests positive, the reality is anybody could be positive at any time and none of us actually know because there's been so little testing out there. So you need to check with the town safety guidelines, the state safety guidelines, look at OSHA. And then if you have to shut down, then we're back to those contract clauses again. You know, the owner is going to be up in arms because you have to shut down. They've got a construction loan. Now the project's gotten delayed. They're paying interest. And who's going to be responsible? From an insurance standpoint, I don't know. I think, Tom, you should talk a little about workers' comp. I'll just put it on the next slide.
All right, so there may be some people here. Workers' comp, there's 50 workers' comp laws. Every state has their own workers' compensation law. Different states will interpret a communicable disease different. In Massachusetts, it is almost impossible for somebody to collect workers' comp due to a communicable disease. Really, the only places that I've ever seen it happen is if you can prove that first you have to show that the communicable disease is inherently part of your work. And then secondly, you have to be able to prove that you picked up the disease at work. Now, this is supposedly such a contagious disease, you could pick it up absolutely anywhere. And even if I'm a nurse working in a COVID intensive care unit, and if I'm tested positive, did I pick it up there? Or did I pick it up in the bus on the way home? Or did I pick it up when I was at the grocery store? Because there's 23 people at the grocery store that have it. In Massachusetts, it is very difficult to be able to collect on a workers' compensation issue because of a communicable disease. You go to some of the surrounding states, and it's much easier to get a compensable. If you collect, if you were to get sick and could show it was from work, it's in New Hampshire, it's much easier to prove it than it is in Massachusetts. So every state has their own rules on that. So I think that's one of the things. The other thing that I wanted to make sure everybody knew about was that as there's 50 different workers' compensation laws, there are different people that administer the program in different states. And there's one organization, the National Council on Compensation Insurance, that administers workers' comp in 37 states. What they have said is if you are part of the PPP program where you're paying your workers to stay home, and they are truly not working, then NCCI has actually come up with a new workers' compensation classification so that there's no charge for workers' comp if you're paying people to stay home and not work. And it's important for people to know what's happening in their state, because if you're paying people not to work, you want to make sure you're not paying the workers' comp rates on those people. I know in some states, the rate for a residential carpenter could be 25 to 30% of that person's payroll. That's a lot of money if you're saving it to pay these people to be home for 2 weeks or for 2 months. So you need to have a discussion with whoever's writing your insurance and find out how does the insurance affect the fact that people are home and not working.
So Tom, you're saying people can either get refunds or they can get reduced premiums for workers' comp insurance while people are at home.
If they are not working.
Liability? Sorry?
All right, so first off, they have to be home and not working. If they're working at home, then it would be the same rate they would always have. But if they're actually being paid not to work, then there is a reduced charge or no charge for the workers' compensation. On general liability, again, if they're being paid not to work, you need to talk to your insurance people and find out how that is being charged. Several insurance companies have said if you're paying your laborers to stay home and they are not working, there'll be no charge for those people for general liability.
So
Okay, go ahead. No, you go ahead, Andrew.
No, I was going to say, so you could save a significant amount of money in your insurance premiums while people aren't working.
If they are not working, correct.
That's interesting to know. We have a few more questions here, and I know we try to keep these at about 30 minutes, but we've had a lot of information. I know a lot of people have a lot of questions, especially about PPP and how this is all working out, and that's really interesting to know about workers' compensation. Gerard, who is a general contractor in Long Island, he asks if a client cancels an executed a renovation contract with down payment paid, but work has not been started as of yet, and the client now wants to cancel the contract, either due to loss of job or a pandemic. Is the contractor entitled to his profit without doing any work?
Depends what contract, and this does depend on state laws, so be careful. If your contract says the deposit is not refundable, then you could theoretically keep the deposit. If the contract says that if either party cancels the contract, that they're entitled, in construction, let me take a step back. If I cancel a contract, it depends if the contract has what's called termination for convenience. That is something that you see in construction contracts quite a bit. So if there's termination for convenience, that means I can cancel the contract without breaching the contract. In the event of a termination for convenience, it can say a lot of things. It can say, I'm entitled to my profit and overhead for the full job. It can say I'm entitled to profit and overhead for the amount of work completed to date. It can say all kinds of things, okay? If you don't have the termination for convenience, then the contractor has an argument that they have now breached the contract because I had a contract with you. You said that I could do the work. There's nothing in the contract that says that I have to stop, that I have to cancel the contract if you've lost your job. I mean, we don't need a pandemic for this. There's case law out there about what happens when someone cancels a contract. So again, this is all about shifting the burden of who's going to bear the financial cost of this. So as contractor, I have to think about whether I would be entitled to the full profit and overhead. It depends what my contract says.
Andrea, we've got another question, a follow-up from Gerard. I mean, it's such a practical question here. Can a contractor ask a client with an executed renovation contract that in consideration of COVID-19, we need to charge the client's fees to purchase PPE, sanitation equipment, and hire additional crew to constantly clean and sanitize the job site?
Okay, that's a fantastic question. And that issue actually came up even in Massachusetts after Katrina. We started putting in our contracts that if there was more than a 10% increase in the price of materials, which happened after Katrina, that we had a right to charge more. So the answer to that question is you can always renegotiate, okay? It doesn't mean the other side's going to agree. They have to agree, but you can always try to renegotiate. And what I have recommended, and I have a couple of blogs, people can take a look at that, is try to get the other side to renegotiate and then create a document that you call an addendum. It doesn't have to be fancy. You don't have to use legalese, that says exactly what Gerard just said. In light of the increased costs, we agree to pay X amount more. It doesn't mean they'll agree. You might have
Right.
to lose money on that job.
Well, we do have a number of more questions, but I know I wanted to keep it on the shorter side. Do you have a few more minutes, Andrea?
I do. I think Tom does.
It sounds like that last question maybe is a blog article you can write for the Expert Center. New York also has a 3-day clause to cancel the contract after signature from the homeowner. How does that affect things? I mean, I know you're not a lawyer,
The
but
answer is, first of all, I mean, I have to tell you quickly, unless it would be wasting time, how those 3-day clauses came about, because it's actually kind of interesting. They came about because of back in the day when we had door-to-door salesmen, and they would come, and like the Fuller Brush guy would come with his brooms and sit in your house, and the feeling there was a power imbalance in that they were imposing these contracts on you. So you should have a 3-day right to cancel. Well, that 3-day right to cancel, we have that in Massachusetts too. In fact, I think you're going to find that in a lot of states. And that's just like when you get into a mortgage. At the beginning of the contract, you know, the owner has a 3-day right to cancel. The caveat in Massachusetts is only if the contract is signed in the homeowner's home. If you sign a contract in your showroom, you don't have to give them that 3-day right to cancel. So
wow.
it doesn't really have anything to do with the current pandemic, but I put in my contracts, here's a giveaway, that the contractor will not start working until the 3-day right to cancel has passed.
Okay, I'm going to do one more question because we're getting flooded. So I'm going to ask that maybe some of these questions are posted on the Expert Center afterwards. But Dan,
Email me.
yeah, great. Dan had asked, will it meet the insurance physical damage standard if property is damaged because it's vacant? No one is allowed to be on site due to the stay-at-home order. For example, there was a leak and no one was there to notice it or to address it before it became advanced. If so, then there's a loss event caused by a force majeure. So in theory, the other related costs could be covered.
Great question. I know Tom's going to answer it, but I just want to say something there. In law, you have what's called a duty to mitigate damages. And this is where we go back to the first slide with common sense. If you've got a house and you're halfway through, you need to button up that property before you leave. And I am not aware of any jurisdiction where they said to the construction industry, you've got to lay down your tools and leave this minute because of COVID. Now we'll find out from Tom if your insurance is going to cover you if that happens.
The policy does have a vacancy clause in it. Most of them, it's 60 days. And again, vacancy is a defined term. If all of the business property is still there, they haven't moved the chairs, they haven't moved the tables, and the place isn't vacant, it's just not being used. So any peril, anything that happens that's physical damage would be covered. You have a pipe that leaks, you have something that freezes, you've got a car that comes through the front window, that's absolutely physical damage, and those things would be covered. And then you may be able to make the argument that the business interruption, the fact that I have to be closed for 60 days is because of the fire, not because of the order not to open. And you may be able to make that argument. So
Seth, just a quick question for Tom, because it's something I wanted to make sure we covered, okay? In the scenario where an owner sues a contractor for transmission of the virus, is your liability insurance going to come in and defend you if you're accused of transmitting the virus to the owner?
Most policies today are based on forms that are written by an organization called the Insurance Services Office. And in 2009, the Insurance Services Office wrote an endorsement to the standard liability policy that would exclude any claims that arose out of viruses, bacteria, or funguses. That's something that is not on a lot of policies. We don't see that endorsement used very often, although I received notification just this morning that one of the national carriers is going to add that to every policy on renewal after July 1st. So, you know, although it's been available since '09, we don't see it a lot. It is around on some policies, but I expect to see it on a lot more going forward. Did that answer your question?
Yeah, exactly.
Well, I just wanted to thank you both and kind of wind down here and say that I'm sorry to Janet and Scott and a number, Paul and a number of people that we weren't able to get to their questions. But like I said earlier, please post these questions on the Expert Center. We put it in the chat. These are the kind of questions we want. Get Andrea or Tom or other lawyers' opinions to answer them. And of course, I really want to thank Andrea and Tom, and their information is up here too. If you're in the area, Andrea or Tom would be the people to contact for legal and insurance needs regarding this. And I think it's just amazing how topical and how laws are changing and how we're forced to deal with this entire new event. So again, thanks everyone. Again, my name is Seth Bloom. I'm Senior Director of Attorney Services at Levelset. Check us out on the Expert Center. And Andrea, Tom, we really, really appreciate your time and helping our community, because that's what we're about, helping first. We want our contractors to get as much information as they can so that they can make it through this pandemic as least scathed as possible. So thank you to everyone, and have a great day.